fights with passion, and he inspires.
Are you ready for a war?
All right, welcome back to From 8 Arbitration. We're going to have a long episode today. I'm talking about a long episode today. And so y'all hang in there with me. It's going to be a lot of reading. I got a lot of sites. We're going to cover two specific things. One, a mandate that's been given out by National, and another decision that came out this week that has gotten a lot of our leaders in the union acting like bitches and cowards. And so I'm going to address this decision that's come out. You can tell those that are used to fighting and those that are used to being cowardly bitches. And so I'm going to talk more towards the fighting side, how I've been raised, not the cowardly bitch type that has come out after this decision, and I'll speak about that in just a second. I'm going to go on and cut to the chase on this thing and get this out of the way at the very beginning, and then I'm going to do some shout-outs and some other stuff. The rumors are true about me, the ones that have been coming out here lately. I have been talking to several people that are very influential to me and that I respect greatly. I've been talking to them for about a couple of weeks, if not longer. James Henry is one of those, and we've talked extensively lately. And I have agreed to become the director of city delivery on the CLC ticket. I'm no longer going to run for business agent of Region 8. We will put somebody in that place to win that business agent position, and that's exactly what's going to happen. This administration that's in there now will be gone, and I'll talk about that in just a second. But I have agreed to be the director of city delivery on the CLC ticket, only after James Henry has told me that he will give me free rein to come down on management in this country like nothing we've ever seen. And I'm adept at that. I've dealt with that in this region at the national level, on the National Safety Committee. I'm adept at that. At raining down straight hell on those individuals that have sought to harm my people. And in that capacity, and I'll read to you what responsibilities that entails. In that capacity, I will surround myself with those dogs of war that have one thing in common: fighting. And I'm talking about fucking fighting. Getting the fuck into it at every fucking level. I'll talk about that in just a second as well. But James Henry is putting together, when you talk about motherfuckers going motherfucking, when you talk about those individuals that you roll up and say get in, and they're getting the fuck in and you're going motherfuckering, he's putting together that ticket, like I told you he was, that will be unlike anything y'all have ever seen before, that will burn down the NALC as we know it today, what it stands for, the cowardice that I've been talking about for so fucking long. It will burn down that cowardice and fear and that party-like atmosphere, that frat house type bullshit that we've been dealing with for so fucking long. It will burn that shit down, and out of that will rise, when you talk about that phoenix rising up out of those ashes, will rise those motherfuckers that are going motherfuckering. A new day has dawned on the NALC, and it's coming in 2026. I give you my word on my life, that's what's coming. I will be the next director of city delivery for the NALC. And in that, when I was talking about the vital few a few weeks ago with management, when they talk about our vital few with accidents and attendance and slips, trips, and falls and things like that, one of the things that I'm going to do, day one, I will have those dogs of war that I will put together, and I will send them out around this country. And we will deal with those managers at every single station that have sought to bring my carriers harm and have thrived at making their workplace toxic. That will be dealt with day one. I will have those teams in place. We will have, obviously, business agents that have their own teams, but I will have my own teams that I will send out on our dime to spend a week at certain stations where managers have decided that they will do everything within their power to be toxic to my people. That will happen. James Henry has decided, when he talked to me, that the Boogeyman is back. And the Boogeyman is back in this game. And I will rain down hell on management during my time as Director of City Delivery. That's a promise from me to you, to labor, to management and supervisors across this country, because I know they listen. A new day is dawning with the NELC. The Boogeyman is fucking back. And I will do whatever it takes to protect every single city letter carrier in this country. Unlike anything that management has ever seen, and unlike anything this union has ever seen, James Henry has given me carte blanche to protect the city letter carriers, and that's exactly what he said. He said, you protect the city letter carrier at whatever cost. And that's exactly what I'm going to fucking do. I've been preaching about it for too fucking long. About the city letter carrier. The love I have for the city letter carrier. And seeing the shit that drives me crazy about what's happening to them. And I'll talk about it in just a second, some of the things. Now, I'm going to be interviewed by Mr. Speakman in a couple of weeks, and he'll go over kind of my platform. What I'm going to do, from day to day. One of the things every week, every Tuesday, I've already decided, every Tuesday I'll have a national Zoom. Whoever wants to listen. And I'll have a national Zoom and I'll tell y'all exactly what I did the prior week. Who I talked to. What's going to happen. What's coming. What could potentially be coming. Every Tuesday I'm going to do that. That has never happened before. But y'all want transparency? Transparency's coming to the NELC. We are turning the NELC back over to the city letter carrier. It is not going to be a frat house any longer, run by womanizers and drunkards. It's not going to be that way. It's going to be those individuals that put the city letter carrier first, and there is no second. I have preached that for far too fucking long, and that's one of the things when they were talking to me about it. I said, baby, I'm going to have free fucking reign to do whatever the fuck I've got to do to protect my people, to educate my people, and to put my teams in place that will go be detrimental to management's livelihoods. We will be going after management's jobs in force as soon as I get in there. I will still be doing this podcast every Sunday. Every Sunday, educating. Every Sunday, telling you exactly what's going on. Y'all want transparency? It's coming. It's coming. James Henry is not fucking around with this ticket. I can tell you that. It's going to come out, so, it's not like I'm going to lie to you. He is not fucking around with this ticket as far as protecting the city letter carrier. That is his mission, and he'll talk to you about it later. Probably at the end of January, beginning of February, you'll hear some more about the ticket. That will blow your fucking socks off. When I tell you the motherfuckers are coming, they're coming. They're coming. I will be hell on management during my tenure as the Director of City Delivery. I will make a point of it. They will not run shit any longer. These memos will be thrown in the fucking trash. If it doesn't protect the city letter carrier, I'm not interested in it. When you meet with labor at that level, they have one thing on their mind, protecting the service. We should not be in bed with them like our current administration is. We should not be in bed with them like it is today, and I'll talk about that in a second. Everything we do will be to advance the city letter carrier craft. That's exactly what's coming. When I was at the jail years ago, there was a gentleman that came in. He was a personal confrontation trainer. His name was Levi Montgomery. And what his job was, he would come in and get groups of us, the guards, the correctional officers. And he would teach us pressure points if two inmates were fighting and you could not get them unlocked, which happened. Once they get locked up, it was very difficult to get them unlocked. So if they refuse to get up out of a chair. You're talking about intake and stuff like that. He would talk to us and show us pressure points behind the jawbone, in the neck, where you put enough pressure on something, no matter how big they are, they're going to do exactly what you say. You've got to put enough pressure on that individual for that to happen. This position is no different. I will be constant pressure on the Postal Service until they give up. I've done it my whole entire career. People saying, well, how are you going to do that? I've done it my entire career as a shop steward, as a Formal A, as an advocate. You put enough pressure on them, they'll do exactly as you say. We've seen it through the grievance procedure, Lake Charles. Seen it through my station when they come and try to bust us up, the amount of pressure you can put on them through the grievance procedure. When we talk later on about the public, about these videos that are out, putting pressure on them. Now you see Congress and Senate putting pressure on the Postal Service. We will have a direct effect on that, right? A new day is coming for the NELC. It's inevitable. It's coming. One of the things you've got to remember is James Henry is having to put together his own ticket, right? He's having to put together the resident officers. He's having to travel to talk to those individuals that are coming on board. He's having to look at each region. Now, which business agents are we going to replace? Who is it that's in line with protecting the city letter carrier? And who is it in line with protecting Renfro's sorry ass? And so that's what he's going to have to look at, and that's what he is currently doing. He's putting together those individuals that are going to put the city letter carrier first. He does not have the luxury of not putting together a ticket like other individuals. Mr. Cariff, he's running by himself. He's not having to spend any time whatsoever putting together a ticket. He's not having to spend 1 second talking to anybody about resident officers. He's not having to spend one dime of his money going, traveling, looking for business agents, talking to individuals. What's your mindset? What's your philosophy if you're to come on board? And so a lot of people chattering on social media about where's James Henry, the CLC's behind this, the 8-ball. No, we're not. It's the exact opposite of that. This man's putting together a ticket of dogs of war, of those individuals who are decided for the rest of their career to put their foot in management's ass and protect the city letter carrier. So that's what he's doing, and he will talk about that later. But that's what he's spending his time doing, is putting together a slate, a ticket, unlike others who are not. They will let somebody else put together a ticket, and then they'll run for president, and just if they win, they'll use somebody else's ticket. So that's what's happening there. James Henry will be the next president of the NELC. There is not a doubt in my mind. And there will be a second and third place, and they will be distant second and third. I know that for a fact. That's coming. The CLC will run the NELC in 2026, and they will put the city letter carrier first, like it should have been long ago. So all that to say, the fucking boogeyman is back. He is back in the fucking game. And man, I couldn't be more excited. I couldn't be more excited to let that motherfucker loose again, like he used to be. Shit's fixing to get fun in the NELC on these workroom floors. I'm going to have some motherfucking dogs of war going across this country, fucking shit up. Managers want the spotlight? Baby, I'll bring it. They want to cause controversy and despair on my workroom floor? Baby, you're going to see me. I'm going to read something in a second. It's going to piss you off. But those individuals, like this thing I'm going to read you, they will put the spotlight on themselves, and I will be there. My teams will be there. Those teams that I assemble, that will travel wherever and do whatever to make sure that the city letter carrier will come to work enjoy their time at work. We already fuck with enough shit through weather, through volume, through packages, through dogs, through heat, rain, slow. We already deal with enough shit that we don't want to come in and deal with some stupid ass fucking manager that don't know what in the fuck they're doing. The only thing they're good at is fucking with us to make their bosses numbers. We will get that under control. Right? I'm going to read something to you. And this kind of pissed me off because it gives the example, it's the perfect example of the fucking cowardice that has taken over our union. The cowardice and fucking trifling ass attitude of our business agents' offices and stuff like that. And it's about a decision that came out this week out of Region 3. And it was not a good decision. It was not a good decision. And this arbitrator, it was a contract case dealing with an escalated monetary award. And this arbitrator took great exception to that. And the language was kind of unnecessary. Kind of calling us crooks. And we had some kind of scheme, illegal scheme to get these monies off of this grievance procedure. And we were doing things like embezzle. It was basically criminal conduct on our part. It was over the top, really. But it was how the union responded to it that kind of pissed me off, because it would still be, at the end of the day, it will be one site in an ocean of 1,000 sites. It will count as one site. Matter of fact, it wasn't even a loss. It was a modified decision. He granted some portion of relief, but he kind of went off on us about other things in there. And it was kind of, like I said, it was over the top, really. I'm going to talk to the business agent's office that's bitches and cowards. I know that Barner probably shit his pants, and he probably is sitting around telling people, nah, my counterpart called me. We talk all the time, and he called me. And, man, he just throwing that decision up in my face, because Barner's a cowardly-ass motherfucker as well. And he's one of those that has gotten us in the position we are now with this cease and desist bullshit, because his partner has bought and sold that motherfucker on cease and desist. That's the reason we're having so many issues with noncompliance. You got these pre-arb sessions. That's another issue we're having with noncompliance, for the sole purpose of saving the union money. The union is not in the business of saving money. The union is in the business of protecting the city letter carrier. And so there's no doubt that Barner's somewhere talking about this decision. And probably Lloyd called him. They talk several times a week, and Lloyd's probably looking at this decision, throwing it up in our face. It's one fucking decision. And if you have war fighters, if you have those that are used to getting in the fucking fight, getting in this game, they will see that decision, and instead of being bitches and cowards about it and getting in a fetal position, they will educate themselves and understand how we're going to defeat that decision coming up. And I'm going to show you how to do it. Because I'm not a fucking cowardly motherfucker like these business agents' offices, like your Barner. When shit goes down, the fighter does what? Motherfucker stands up and fights. I'm going to read this to you, what a business agent's office sent out about this decision. And listen to this shit here. It was a bad decision, okay? It was a bad decision. The arbitrator obviously took exception to some of our arguments, which is fine. That happens. He went overboard as far as calling us crooks and criminals and shit like that. But here's what this business agent's office sent out, and courtesy copied every advocate and everything in this region. It says, please see the attached award and be prepared to see it as a cite from management for any and all compliance cases which the requested remedy asks for monetary incentive to comply. So now they're setting you up that that's a bad thing. Any kind of escalated monetary award, just look for this decision. Any case you have that requests that. Now, first off, we go first in contract cases, so it's our burden. Well, how am I going to know that I'm going to see it? Because they go last. They're going to put it in after my closing. I'm going to show you how to defeat that. So remember that when they're talking about be ready to see this, well, I can't address it if I go first. They're going to put it in and talk about it last. I can't object to it. I can't say when they're finished, Mr. Arbitrator, do you mind if I address this one site? I'm going to tell you how to beat it, though, here in just a second. Be very easily beatable. Here it goes. This is a perfect example of why we do not go to arbitration over every grievance that asks for monetary remedies for noncompliance. In addition, this advocate, according to the award, refused to cooperate with the arbitrator when asked direct questions. For the arbitrator to feel the need to say what he says in this decision, I can only assume how defiant the situation was. Clearly, this case never should have gone to arbitration. The decision to go forward not only failed the branch, it failed the region, and it failed the entire NALC. Let me read that again. The decision to go forward not only failed the branch, it failed the region, and it failed the entire NALC. Now, you would think that this would have been a national arbitrator's decision that was just handed down, not some regional decision that's put in for persuasive value. They're elevating this decision to a national level arbitrator's award because it's saying not only did it fail the branch, it failed the region, and it failed the entire NALC. When I tell you that there's a new mindset coming into the NALC, we're going to burn this old mindset to the fucking ground. And out of that's going to rise this fucking phoenix of motherfucking fighters. When I'm the director of city delivery, if I ever see an email like that, that motherfucker's going back to delivering mail. I will not have cowardice in any position under me. That will not happen. Cowardice is dead in 2026. This CLC will make sure of it. Fear is gone when the CLC takes over. Anybody sending out some shit like this will be back to delivering mail the next fucking day. We will not fearmonger any longer in this motherfucker here. The only fear that will be experienced when the CLC takes over in 2026 is from management. They will fear us. I know that for a fact. Too many people are already talking about the potential of the CLC taking over. Too many managers are already talking about the consequences of the CLC taking over. Because they know they've got it made with these motherfuckers in there now that are scratching their backs and kissing their asses. I'm going to go on. One of the hardest things we do as stewards is telling our people there is no grievance and or telling our people they will not get everything they want, which should have been done in this instance. Fighting for the sake of fighting doesn't make you a warrior. It makes you incapable of resolution, eventually weakening your position because you're not taking seriously. Social media is full of folks that want to fight, but there are consequences, particularly when we get our asses kicked. And the consequences are not just local, they encompass the entire country. Please take the time to read this award and be ready to counter it when you see it. Now, how are we going to counter it? Like I said, we go first. But here's an individual saying that this award affected the entire country. Fighting for the sake of fighting doesn't make you a warrior. It makes you incapable of resolution. Eventually weakening your position because you're not taken seriously. Social media is full of folks that want to fight. Baby, we need more motherfuckers that want to fight. Let me tell you, because we're full of fucking cowardice in our business agent's office. You could have an individual, remember when I had my friend that her purse was stolen and all of her union documents were stolen, and that business agent's office wouldn't even give it a cease and desist? You could have that, if that's what you're talking about, if that's what you're wanting. You could have thousands upon thousands of grievances at New Orleans getting sold for pennies on the fucking dollar. We could do that if you're talking about fighting. We could be that kind of cowardly motherfuckers that refuse to fight, that don't know how to fight because we have never been in the fucking fight. Most of the time that people talk about arbitrations and the fear of arbitration have never put on a fucking suit to go into arbitration. Barner, these business agents' offices, these RAAs, they talk about how much fear they have, just like this fucking email about you got to fight. These people talk about warriors and wanting to fight. Motherfucker, y'all ain't fought for nothing. Y'all ain't fought for shit. You've been sitting behind a fucking desk for too fucking long. You have forgotten about the fight on the fucking floor. We're fighting on the fucking floor, man. We need more motherfuckers that say fight, fight, fight. An email like that comes out under the CLC, that motherfucker will be gone the next fucking day. You will not persuade anybody not to fight. We will train individuals about noncompliance, how to get those remedies of noncompliance. We will educate those individuals on that. The education that's coming under the CLC will be unprecedented. I'll be over that. I'll read you the responsibilities of this, and then I'll continue on with some more shit. Here's the responsibility of the Director of City Delivery. Director of City Delivery, Section 6A. The Director of City Delivery shall serve under the direct supervision of the President. And we've already talked about that. I told you that the fucking Boogeyman is back. The Boogeyman is fucking back. B, the Director of City Delivery shall be in charge of all organizational activities relating to the city delivery service, including but not limited to the preparation of materials for training programs. The training that we will put out will be unprecedented. When you talk about cases like this, whether it should have gone or shouldn't have gone, that's not my decision. That was the business agent's decision. Obviously, they looked at that case and thought that they had something, or it wouldn't have gone forward. The business agent is ultimately responsible for what gets in front of an arbitrator. So the business agent's always probably looked at it and said, we have a little something here. You know what? We misread it. The arbitrator didn't agree with it. He didn't side with us. He gave us some language that was not very good, you know. C, the Director of City Delivery shall be a member of ex officio of the National Joint City Delivery Committee established by Article 41, Section 5 of the 1973 National Agreement between the National Association of Letter Carriers and the United States Postal Service. D, the Director of City Delivery shall make a complete report of their acts at each convention of the National Association of Letter Carriers. E, the Director of City Delivery shall perform such other duties as may be assigned to them from time to time by the President. And then it talks about the financial situation, about the financial package. The education that's going to be coming under the CLC will be unprecedented, like I said. We will make sure that when cases go to arbitration, it supports an escalated monetary award. We will not bow down and completely forfeit and forget everything we've ever done because of a decision. We will not turn into fucking bitches and cowards because of one fucking decision in a sea of decisions, of sites. We're not going to do that. We will not lay down in a fetal position because we lost a fucking arbitration. And let me talk to the advocate that did that case. I have had too many people reach out to me about you, sir, about how smart you are and about how thorough you are. I know that you're in a group of other advocates that talk to each other and help each other. And they say that out of all of them, you, sir, are the one who knows the most and helps the most. Take this decision, read it, be upset about it for a day or two, and put it fucking behind you, man. I've had 30 fucking losses in my time. That's 30 arbitrations I have gone in there. Or 40. Hell, I can't remember. 30 or 40 losses in my time. I have agonized over each one. Each one of them I've hated. And I thought the arbitrator got it wrong. It is a site amongst thousands of sites, brother. Nothing more than nothing less. It will only count as one site. And that one site only pertains to the circumstances in that particular office. Nothing more, nothing less. You're a fucking good advocate, man. This shit happens. We get decisions, man, that don't go our fucking way. It's just the way it fucking is. Here's how I would beat that decision. When they talk about be ready to see the decision, I'm going to put in the decision. I have done that before, and if y'all have listened to my past episodes, when I tell an arbitrator Lawrence Roberts was one of them. He ruled against us on one. I did not agree with it. I thought it was a horrible decision. And in my closing, I said, Mr. Arbitrator, in this decision here, you stated this. We took it, we learned from it, and we moved on from it. That's exactly what you do with this decision. Hand it in yourself and tell the arbitrator, Mr. Arbitrator, in this decision here, You took exception to the union's position. You didn't agree with us, arbitrator so-and-so, on this decision here. And we took that decision, and we looked at that decision, and we learned from that decision. But that decision does not pertain to what we're dealing with here today. What we're dealing with here today is an escalated monetary award that's been given by prior arbitrators or prior B team decisions or prior formal Step A decisions. It has now reached an egregious level. And so, Mr. Arbitrator, unlike that decision, these are different. That's how you beat it. It's that fucking easy, man. We're not going to run around like our fucking hair's on fire because one fucking decision. I'm going to read some of these, some separate decisions for you. Here's one, and you can use this one. The union cites to an exhaustive and frankly exhausting litany of dispute resolutions reached with Anchorage, all of which in essence merely have management agreeing to do things in the fashion that they have already committed to doing them. Those agreements and settlements are nonetheless repeatedly and inexplicably violated. Agreements between labor and management are binding and must be complied with by both parties. Even though such a proposition is painfully obvious, it was underscored by Postmaster Donahoe in his May 31, 2002 letter to all levels of management, reminding them that compliance with grievance settlement is not optional. No manager or supervisor has the authority to ignore or override a signed grievance settlement. The message does not seem to have impressed some individuals. As soon as January of 2003, the management in Anchorage was compelled to enter into a legally binding agreement with the National Labor Relations Board to settle pending charges by promising that they would then and into the future comply with grievance resolutions agreements, grievance settlements, including the agreement and final arbitration awards. Despite the above, the Anchorage installation remained embroiled in disputes over compliance with prior agreements. Management participated in the price to height calls, but repeatedly failed to have the appropriate manager with knowledge of the situation on the call. As a result, additional grievances were generated, cluttering the dispute resolution process, and appropriately enough resulting in additional binding agreements, often at the Formal A level. In the following cases, Formal A settlements are reached, and he has several there, with each settlement again solemnly promising that management agrees to comply with the provisions of the price to height agreement in the future by having the local supervisor manager 204B who is involved in the dispute participate in the conference call. This is in order to better facilitate resolving the issue for the local parties. Despite the very plain language of those settlements, management persists in failing to comply with the obligation to have the relevant and knowledgeable manager on the call. Indeed, in the present case, the employer openly asserts in its closing argument that it does not feel bound by those settlements as they were purportedly bad decisions. In making such an argument, the employer underscores its own bad faith bargaining and indeed commits an express violation of the prior NLRB settlement by which it solemnly committed to the relevant federal prosecutorial and adjudicatory agency in a binding settlement that it would in the future comply with all signed grievance settlements. Nor is this first arbitration case to address the question of the employer's obligation to comply with prior settlements, nor is it the first to reach the obvious and indeed inescapable conclusion that they must comply. The union at Step B cited to directly on-point awards by arbitrator John Abernathy and Janice Irving, both arising out of the Anchorage and both affirming the proposition that reneging on prior agreements is impermissible and constitutes bad faith. The union further relied at Step B on awards being between the parties arising at other locations and reaching the same inevitable conclusion included by arbitrator Glennis Gilder, arbitrator Claude Ames, and arbitrator Carlton Snow. The price to height agreement was designed to facilitate the early and expeditious resolution of a particular class of disputes. The Anchorage management has repeatedly sabotaged that effort by attempting to evade the plain language of that agreement. The Anchorage management has nonetheless repeatedly renewed its supposedly solemn agreement to comply with all prior settlements and with the price to height agreement in particular. Here, the Anchorage management has again violated the price to height agreement by not having the appropriate supervisor present for the teleconference, thereby subverting the efficacy of the conference. In the present case, the Anchorage management openly attempts to disavow prior formulated settlements by which it reaffirmed its commitment. Then he talks about the award. And he says this, further violations will result in enhanced remedies, monetary or otherwise. And that's what the union put in. Given the multiple prior violations, and more importantly, given the repeated acknowledgement by management that had violated its obligations, and the repeated promise that it would not do so in the future, and given that the violations strike at the core of the parties' agreed upon dispute resolution system, an enhanced financial remedy would not be inappropriate. Indeed, such a financial remedy is not a remedy that an arbitrator would lightly create. Here, the union has not sought a specific financial remedy from the arbitrator, and so none will be awarded. Although such a financial award was appropriately made by arbitrator Janice Irving, in this case, involving the same anchorage installation. The parties should in the future proceed with the clear understanding that in the event of another indistinguishable violation, an arbitrator, including this one, might well award a substantial financial remedy to better deter additional violations. I'd put that one in there. Do you know why? It's from the same arbitrator that handed down that other award. It's from the same damn arbitrator that handed down the other award. He says, might well award a substantial financial remedy to better deter additional violations. It's not that fucking hard, folks. We do not have to get in a fucking fetal position because we lost one fucking site. We don't have to send out emails saying we don't need to fight. This one hurt the entire country. This one hurt just regions and this local branch. And everybody, every city letter carrier was negatively affected by this award. What in the fuck has happened to us in these business agents' offices? How in the fuck can you come to that conclusion? If you read it, you understood what he was saying. He was not happy with the system that the union had in this one station. He's saying they were overwhelming the management with 94 grievances. And when they couldn't comply, they took $1.68 and made a $38,000 payment or $60,000 request. He said that's larceny. He went off on it. Okay. We lost one decision. Do you know how many that goes down on that young man's record? It's a modified decision, so in actuality, it was a win because it wasn't denied. It was modified. It's one fucking decision. I would hand it in, like I said. In this case here, Mr. Arbitrator took great exception to the system that the union had in place here. But in this case over here, you said that if the case file warranted a substantial financial remedy, you would grant that. In this case here that we're talking about today, there's 27 formulated settlements. There's 10 B-team decisions. There's 3 arbitrators awards who have issued a monetary award. We ask that you follow the guidelines you set forth in this decision. That if a substantial financial remedy be given, that's what we ask here. There's no games being played by the union in this case we got here today. This is a case where management's been told to comply and they refuse to do so. You're the only avenue we have to make them come into compliance. And they have determined that a financial monetary award as is isn't going to make them comply. So we're going to ask that you escalate that for an incentive for future compliance. Because what we want to happen is for this to stop. If they would not, if they stopped, you would never see my face again. If y'all listen to my episode where I played that closing, that's exactly what I said. Comply. It's that fucking simple. But you have people that you lose a fucking decision, and it's to embolden or bolster their position of escalated monetary awards because this administration is so against it. They're so against compliance. Anytime you ask them about compliance, these fucking knuckleheads don't have the first clue how to make management come into compliance. I do. I know how to make them come into compliance. I've done it for far too fucking long. The first thing you don't do is you don't fucking bend over and pull your pants down in front of labor and say, here you go, man. That's exactly what Barner's doing with this motherfucker that he's against. He's having this motherfucker pimp him out, telling B teams to not put down a cease and desist. You are killing us as far as noncompliance doing that. You have these emails going out telling people don't fight. Quit talking about being warriors. Noncompliance is killing us. Fuck, man. We are no longer in it for the city letter carrier in this union. We are in it for management and our own fucking wallet. That's what we're in it for. Here's another decision I would use. The employer in this instance makes a cogent and comprehensive argument in support of the general proposition that labor arbitrators do not ordinarily award punitive or exemplary damages. Here, the only arguably punitive or exemplary damages sought by the union is the payment of a $500 penalty for the delay in processing and forwarding to the DOL of the CA1 claim. While the union asserts that the ELM provides for penalties for delay, that assertion was not further fleshed out, and on this record, there does not seem to be a specific basis for the $500 sum requested, arising from a brief delay in processing, and therefore that sum will not be awarded. The real and understandable focus of the employee's concern regarding arguably punitive relief is the requested award of $25 per day for the RFI-related violation. The employer is correct that an arbitrator absent perhaps a very extensive record of noncompliance, which is not directly presented in this case, would likely not create such a remedy. Here the argument is misplaced for two separate substantive reasons. First, the financial remedy is not punitive in nature, even though it clearly exceeds traditional compensatory grievance awards. Rather than classically punitive, the sums here are instead coercive. The distinction is essentially similar to the difference in criminal versus civil contempt of a court. Criminal contempt typically yields a sentence or penalty of a specific duration or amount to punish improper behavior where that behavior has been completed. Civil contempt, on the other hand, typically involves imprisonment for an indeterminate duration or similarly a daily fine, with each designed to coerce compliance, that is, to stop an ongoing improper behavior. As is often said, in civil contempt, the prisoner has the keys to the cell in their own hand. Comply, and the penalty stops. Here, too, the employer had fully within its grasp the control over whether the daily penalties mounted. Simply, the employer needed to, in good faith, answer the RFIs. Second, the arbitrator is not here, in fact, being asked to create or impose the $25 per day payment. The parties have agreed that $25 per day is an appropriate remedy where repeated failures of compliance and hemorrhage have delayed and complicated the grievance processing machinery. The obligation of payment of that sum was created by and mandated by express agreement of the parties regarding this particular workplace. The record establishes multiple occasions where the payment was then mandated in resolution of later grievances, either at Step B or by arbitrators. There is no contrary evidence of a failure to enforce that formal Step A settlement agreement. For this case, on the issue, the arbitrator serves merely as finder of fact, answering the question, did the event occur? If yes, there is no discretion. The settlement language uses clearly mandatory phrasing that sums will be awarded. The arbitrator is bound to impose the remedy designed and mandated by the parties. He goes on, the final dispute between the parties is regarding the ongoing accrual of the daily $25 obligation for the established unwarranted failure to respond to an RFI, and when or if there should be a cutoff date on accrual. The record reveals that at least in one instance, the DRT reached agreement in grievance there that the 25 daily accrual should cease as of the date of the Step B resolution of the grievance. A different outcome occurred in the Miles grievance arbitration with a decision issued on July 19th. Arbitrator Obey enforced the $25 per day sum and ordered that it continue to accrue until the date management fully complied with the RFI. In that award, Arbitrator Obey noted that it is obvious that management and Henry McGee has not gotten the message, as it has a continuous pattern of noncompliance. While it still appears that inexplicably management and Henry McGee has not gotten the message, this award will follow the accrual methodology of the referenced DRT resolution rather than that of my esteemed colleague, Arbitrator Obey. This award will direct that the 25 daily accrual cease on the date of issuance of this award, premised on the analysis above that the payment is intended to be coercive, not punitive. With full substantive relief having been granted today in this binding award, the union's need for the information sought in the RFI as to the grievance ceases, as the grievance itself is now closed. There is no further point to a coercive payment now that the case is resolved on its merits. And so he did issue a coercive remedy of $250, and he did agree with the $25, although it would be done away with on his decision date. That was the same arbitrator. So you have an arbitrator. If you look up his record, he's had 12 contract cases in the database. The union has won 9 of those and has lost 3. And we're supposed to be scared of that decision? Here's an arbitrator who has said the union has met its burden on 9 of the 12 cases that he's been in front of. He has 2 cases here that say, hey, if you justify it, I will give it. Why are we so fucking scared of one fucking decision? It's because it enforces their position of not taking cases forward for noncompliance. Why we have gotten into that, I do not know. I have no idea why we have chosen to be such fucking pathetically cowardly motherfuckers about noncompliance, which is killing our city letter carrier craft. It starts with Barner. Well, I guess his daddy, Renfro, does it. And he just bannies it about. But these business agents offices that have bought into that shit of cowardice on don't take cases forward. We're not warriors. We don't fight. This is what you see. You see emails coming out saying the dumbest fucking shit, trying to make cowards of everybody to dissuade us from going forward. What has happened to our fucking union, man, that we get so fucking, it was one fucking decision and we collapsed in on ourselves from a damn good advocate. A damn good advocate takes it forward and says, hell, we lost. He didn't agree with us. He took exception to it. There's 2 decisions right there, and they're going to be up on from8arbitration.com. There are 2 decisions right there you can use. Also, don't forget, the most important thing, M1967. Remember, this is the federal court decision that came out about the Kingsport case I did years ago, where the arbitrator awarded almost $275,000 because of one piece of paper. Management refused to give us one piece of paper. It was a training record. We took it forward. The B team said you'll give them the training record. They still didn't give us the training record. Took it forward again. They said you've got this amount of time to give them the training record, and they still didn't give it to us. So we took forward one piece of paper, 2 prior settlements, and the arbitrator said you do not need a canasta deck. It says what it says. Cease and desist means what it means. It means stop and don't do it any further. You have this federal award come out, and management has convinced us from that day to quit doing cease and desist because we weaponized that. One federal court decision comes down and management has bitched us out about the cease and desist. But 1967, make sure you take it because it's very thorough about why the arbitrator has authority to grant a punitive award, as they say. And it's a fantastic fucking decision. I'll read just a little bit of it because I love it. Now a bit about the legal standard under which I'm operating. The federal court's review of an arbitration award is extremely deferential to the arbitrator. It does not require perfection in arbitration awards, but rather dictates that even if an arbitrator makes mistakes in fact or law, a court may not disturb an award so long as the arbitrator acted within the bounds of their authority as defined in the collective bargaining agreement. And I cite Paperworks International Union versus Misco Incorporated 484 U.S. 2938, which held that the court's role is to ensure that the arbitrator was even arguably construing or applying the contract and acting within the scope of his authority and did not ignore the plain language of the contract. So there are two questions that I need to address in this case. The first is whether the doctrine of sovereign immunity shields the USPS from liability for punitive damages. And if you remember that episode, I did an entire episode on this, where management always talk about sovereign immunity. And the second is whether the arbitrator exceeded his authority by awarding a remedy that was not expressly defined in the CBA, which is another thing they always say, that the contract does not call for a punitive award. The answer, as I see it, to both questions is no. With regard to sovereign immunity, the government contends that because the USPS is an independent establishment of the executive branch, it cannot be held liable for punitive damages due to sovereign immunity. The union, on the other hand, argues that Congress waived sovereign immunity as to the USPS and the PRA, and therefore USPS is subject to punitive damages when appropriate. I find that the union has the more convincing argument here. Absent a waiver of sovereign immunity, the federal government is normally immune from suit. However, Congress has waived sovereign immunity for certain federal entities by including a provision that the entity can sue and be sued in its enabling legislation. And I'm citing to Loeffler versus Frank, 486 U.S. 549, 554. If that language is included, then it is presumed that sovereign immunity is waived unless it can be shown that the type of suit is either 1, not consistent with a statutory or constitutional scheme, 2, that a restriction of general authority is necessary to avoid grave interference with government functions, or 3, for other reasons, it was plainly Congress's purpose to use the clause in a narrow sense. In USPS's enabling legislation, Congress stated in no uncertain terms that USPS can sue and be sued in its official name. And I'm citing from 39 U.S. Code 411. In fact, in Loeffler, the Supreme Court held that the language in the PRA gave the USPS the status of a private commercial enterprise, and that Congress waived any otherwise existing immunity USPS from interest awards. This court understands the Supreme Court's holdings to mean that unless one of a limited set of exceptions applies, an agency or other federal entity with a sue and be sued clause cannot escape the liability that a private enterprise would face under similar circumstances. And I'm quoting from Conn versus American National Red Cross, 168 F Super 3D 9095, which quotes FDIC versus Meyer, 510 U.S. 471 482. Thus, I have little difficulty concluding that Congress intended to waive sovereign immunity as to USPS by virtue of the PRA. None of the enumerated exceptions that are listed by the Supreme Court in Loeffler apply in this case. Subjecting USPS to punitive damages is not inconsistent with the statutory scheme. The language of the PRA gave USPS the status of a commercial business, which is consistent with Congress's intent that USPS operate as one. A commercial business is liable for punitive damages when appropriate. Compliance with the award given by the arbitrator will also not materially interfere with the government functions. USPS had $70 billion in revenue last year. Even if the punitive damages award here are the amount that the government alleges, $230,640, it is not an amount that would materially affect USPS's operations. Finally, the third exception does not apply. Nothing in the PRA or its legislative history clearly shows that Congress intended the sue and be sued language to be construed narrowly. Interpreting the PRA's sue and be sued clause narrowly would contravene Congress's stated intent that USPS be run as a commercial enterprise. Accordingly, I find that sovereign immunity does not shield U.S. from liability for punitive damage where appropriate. Now, the USPS argues that the arbitrator exceeded his authority because punitive damages are not explicitly set forth in the language of the CBA. The union counters that explicit language specifying the availability of punitive damages is not required. And again, I find that here the union has the better argument. The CBA here states that all decisions of an arbitrator will be final and binding, and that all decisions of an arbitrator shall be limited to the terms and provisions of this agreement, and in no event may the terms and provisions of this agreement be altered, amended, or modified by an arbitrator. I'm quoting from the CBA Article 15, Section 4.6. It is silent on the remedies available. But the Supreme Court has made it clear that the labor arbitrator's source of law is not confined to the express provisions of the contract as the industrial common law. The practices of this industry and the shop is equally part of the collective bargaining agreement, although not expressed in it. And I quote from the United Steelworkers of America versus Warrior and Gulf Navigation Company, 363 U.S. 574, 581, 82. This is because the labor arbitrator is usually chosen because of the party's confidence in his knowledge of the common law of the shop and their trust in his personal judgment to bring to bear considerations which are not expressed on the contract as criteria for judgment. And again, I'm citing from United Steelworkers. The D.C. Circuit has made it equally clear that an arbitrator may look to the party's past practice and the structure of the contract as a whole may be properly considered by the arbitrator in interpreting the contract and formulating the award. And I'm quoting and citing Madison Hotel versus Hotel and Restaurant Employees. While the D.C. Circuit has not specifically opined on whether punitive damages are available as a remedy when not expressly set forth in the CBA, other circuits have, and there is some disagreement. For example, the Eighth Circuit held that an award for punitive damage was appropriate without express language because the industry practice was to award punitive damages. And I cite International Association of Machinists and Aerospace Workers. The Ninth Circuit upheld a punitive award damages in Gauss Golden West Sheet Metal versus Sheet Metal Workers, International Union Local 104, where the language of the collective bargaining agreement stated that the arbitrator may grant any remedy of relief which is just and equitable and within the terms of the agreement of the parties, language which is slightly more broad than the CBA in this case. This court will follow the lead of the United States Supreme Court and the D.C. Circuit, which have both held that arbitrators may look beyond the explicit text of the agreement in fashioning an appropriate remedy. For one, the CBA here is silent as to the remedies available to the arbitrator, and surely an arbitrator is permitted to order a remedy that is not expressly detailed in the CBA when the CBA doesn't discuss any remedies. In any event, a federal court is not authorized to override an arbitrator's interpretation of a CBA if it disagrees with the arbitrator's approach or would have reached a different conclusion. An arbitral award must be upheld if the arbitrator's decision is arguably applying the CBA. To that end, Arbitrator Roberts did not exceed his authority in ordering UPS to pay punitive damages. As I discussed previously, rulings from the Supreme Court and D.C. Circuit generally permit an arbitrator to go beyond the bounds of the CBA in fashioning a remedy, allowing him to look to industry common law and practice between the parties. Citing arbitrable precedent, Arbitrator Roberts noted that it is generally accepted in labor arbitration that a damage award arising from a violation of the collective bargaining agreement should be limited to the amount necessary to make the injured employee whole. I'm quoting from ECF number 14.8 at 818. However, Arbitrator Roberts reasoned that this does not mean that punitive awards are always prohibited. He then expressed the opinion that punitive damages were appropriate here given that a straightforward cease and desist order cannot be simply ignored as it was in this case. Thus, he concluded that USPS's failure to abide by the Step B settlements reached the level of willful and malicious and clearly represents bad faith bargaining. And she goes on to further justify it. So, they talk about arbor precedents that the CBA does not call for or address escalated monetary awards. And she shot down management's, labor's arguments about sovereign immunity, about the CBA doesn't call for punitive awards. She talks about arbor precedents, and you have arbitrable precedents in the two decisions that I just read to you. So while everybody else in the NLC is going around like their fucking hair's on fire about one fucking decision, sit down, take your time, gather yourself, and say, here's what we're going to do if we're in front of this arbitrator again. We're going to hand in their decision ourselves. Management's going to attempt to hand it in. I'm going to beat them to it. I'm going to hand it in myself. Like I said, I'm going to talk about it right there. We got it. We read it. We understand it. And we learn from it. But it does not pertain to the case we have here today, Mr. Arbitrator. You have two other decisions where you talk about the appropriateness of a potential escalated monetary award. In this case, is ripe with that. And then you have this court document that you can put in there and say, sovereign immunity, they're not protected from it. The CBA doesn't address it, but this judge said that the arbitrator was in their rights to grant this escalated monetary award, right? So that's how we will address that. What's funny is when you talk about shit like that, when you talk about the cowardice of our union and Barner and Renfro and these business agents' office that are weak and cowardly. We had that decision from Memphis come out, one of the biggest decisions on the JSOV, where the arbitrator Swallow, when he removed the district manager who had retired and 3 station managers. That's never been done in the history of arbitration and for the NLC. And what happened after that decision? Did labor go around like a chicken with their head cut off, screaming, woe is me, the sky's falling? Did they do that in that decision? No. Do you know what they did? They got Barner, and they made a joint call and had Barner remove that arbitrator off the panel. That's what labor did. They didn't say quit fighting. They got us to do their dirty work for them. They called our bitch-ass executive vice president and said, hey, we're going to call that arbitrator, and you're going to remove him because of this decision. And that's exactly what happened. The difference between us and labor right now is they will not stop fighting us. They do not cower down like our bitches in the NLC do. They will never stop fighting us. I had another case. It was a window of operation case in Nashville. We were kicking the shit out of management. I mean, kicking the shit out of them. I was the advocate for all of them. And we continued to win these cases. They continued to take them forward, Do you know why they did that? First off, because they quit and they never stopped fighting us. They wake up wanting to fight. It's just that we don't have war fighters in our union anymore. We have cowardly motherfuckers like this email, like Barner. Finally, they got an arbitrator Bayhackle, who does not agree with escalated monetary awards, and she'll tell you, I don't agree with them. The contract doesn't call for them. I will never grant an escalated monetary award. Even if you had one, she will not abide by that decision. She will go against it. If you've got 20 arbitrators' decisions, she will not give you an escalated monetary award. She will say those arbitrators have erred in their decision. That's how bad she is. Finally, they get one in front of her, and she rules against us. Do you know what the union did? They sent out the same fucking email like this. This does not help. This goes against us. I've got 9 decisions to their 1, and we just run around just dropping our draws in front of everybody, so fucking scared of a decision. You know what I did with that decision? Nothing. It was a stupid decision. Do you know what she ruled on? Here's what she ruled on. In my opening statement, I told her, I informed her, Madam Arbitrator, this is not dealing with rule of reason. This is dealing with off assignment overtime. Those carriers that are not on the list that are being forced to carry routes other than their own. And they're in an overtime status, and we have carriers available up to 12 to do that work. That was a window of operation case, right? On this day that we had this one, there was like 24 hours available, and they had a carrier come in on their non-scheduled day. Easily covered that. Take out the window of operation. Had nothing to do with it. Take it out. I had management go over rule of reason. I said, does rule of reason pertain to this case? Does it apply? No, this doesn't deal with rule of reason. Management's witness testified to that. In my closing, Madam Arbitrator, this is off assignment overtime. It has nothing to do with rule of reason. You know what she ruled on? Rule of reason. That's what she ruled on. Did we ask to get her kicked off the panel? Did we have some joint phone call because she fucked up so bad on that decision? No. It was a loss. Go on to the next one. Right? That's what you do. Management will attempt to vacate them. In this case in Memphis, they didn't attempt to vacate it. They just had Barner's bitch-ass call and remove the arbitrator. So that's where we're at. That's where we're at. Over one decision. And the whole country's burning down as far as the NLC. We've lost our fucking mind. I guarantee you Barner's belly aching about it somewhere. Just being a straight-up fucking bitch like he is. And this business agent's office sending out this email, just straight folding in on themselves, just straight cowardly. chastising those that are talking about fighting. Warriors. Chastising them because of a decision from a different region that has nothing to do with shit. It's one fucking decision. Like I said, a new day's coming. A new day's coming. Those that send out those emails, when I'm director of city delivery, not if, but when, and I get a hold of that, I will immediately remove them from being in a business agent's office. They'll be gone. I'm not going to have cowardice. We're going to extract cowardice from the NLC. That's coming. That's the reason James Henry is putting the ticket together that he is. You're talking about a Marine. That's a war fighter. He's putting together a ticket of those hounds of hell, those dogs of war that have one thing in common: fighting. Fighting. And fighting. They are warriors that are used to doing warrior type shit. That's going to be on the ticket. And on day one, we're getting rid of those that do not have that same mindset. There is no room in the NLC for cowardice. And it's rampant. It's fucking rampant. In the movie, if y'all have seen it, and I love this movie, it's Knock Around Guys. It's from guys from Brooklyn. They're small-time gangsters. And one of them's dad is a big-time gangster. And they're supposed to transport this money and they lose it. And they have to go to this small town and try to get it back. And they run into this bar and there's some locals that are trying to run roughshod over them. But Vin Diesel is in this movie, if y'all remember this scene. And he comes up to this guy that's trying to cause problems. And he just says 500. And the guy spits on his boots and he said, "What the fuck does that mean?" He said, 500 fights. He said, "That's how many I've been in when I was a kid." He said, "And that's what made you a tough guy, is 500 fights." He said, "But I forget all about that after that many fights." He said, "But you get leathered skin after you've been in that many fights." And he goes on to beat this guy's ass. This union is going to be filled with those with leather skin that have been in so many fights that shit like this doesn't send them in a fucking tailspin. When you have people that have never been in a fight like Barner, who will tell you that his claim to fame, like I've said 1,000 times, is I've had thousands of cases at the DRT and never passed a one. He is not a fighter. He's a cowardice, right? He's a sellout. That's what that is. When you have emails like this from people who've never been in a fight, they will never have leather skin, right? They will run from altercations. They will run from fights. Just like this email, that's running from a fight. Rather than saying, "Hey, we got this fucking decision. Here's how you're going to address it when you see it again. You're going to put these decisions in from the same arbitrator. Put it in yourself and say, hey, here's what you said. We get it. We get it." Rather than doing that, what do they say? Wait, we got to change the way we do things in this country as far as going forward with cases. We got to change everything we're doing. We can't go forward with what the fuck? You need leather skin representing those city letter carriers. The city letter carrier should be immune from anything happening with the NLC. The city letter carrier should come to work and go home. The NLC should be war fighters, should be those with leather skin, should be those hounds of hell, those dogs of war that come in, fuck shit up on behalf of the city letter carrier so that the city letter carrier can come to work, mind their business, and go the fuck home. Anybody that wants to fuck with that will meet with us. That's what the NLC should be. Instead, we have motherfuckers at conferences saying, "This decision, oh my God, Lloyd called, putting it in my face." Fuck Lloyd. Fuck him, man. If Barner was half a fucking man, he'd say, "Fuck that decision. Fuck that decision. I got 1,000 I'll put in against that one." We don't have those individuals in places of power that have leather skin. Those dogs of war that have been in those fucking fights. And when you don't have that, when you got them because they're yes men, they're ass kissers, right? When you have that, this is what you get. of fucking falling out on our fucking faces over one fucking decision. All right, here's the next thing we're going to talk about. Here's the next thing we're going to talk about. Here's something that came out, and I'm going to tell you how we're going to address it. And this is going on nationwide. All right, and here's how we're going to defeat it. It's going on nationwide. And this is what it states. Call to action. Call to action is what it states. In the event a POD employee observes any of the following. Now, this was a stand-up given, right? And I'm going to put this up. Mallory's going to put this up on from8arbitration.com. And with as well these sites I'm going to read to you. Print all this off and put it in your file if this happens, okay? In the event a POD employee observes any of the following. Unattended running vehicle, not wearing a seatbelt, distracted driving, fingering mail, headphones, earbuds, utilizing cell phone. Okay, so I'll read that again. In the event a POD employee observes any of the following, unattended running vehicle, not wearing a seatbelt, distracted driving, fingering mail, headphones, earbuds, utilizing cell phone. 1. POD will immediately stop employee, identify themselves. 2. Ask employee to shut off vehicle. Remove key from ignition and wait for further instruction. 3. BOD will contact local office EAS and request immediate support. 4. Once EAS arrives, POD will provide all supporting notes, photos, and statements to EAS. 5. POD will remain on site, oversee emergency placement procedure, and offer support where needed. 6. Notified verbally that they are being emergency placed by EAS and then drive back to the office. 7. Emergency placement letter obtained by local labor relations. 8. Email drafted outlining high-level overview with all supporting documentation to team lead. 9. Team lead will review an escalation. The employees, this is at the bottom, the employee's supervisor or manager must be the one to place an employee in emergency placement, not the POD. Employees being placed on emergency placement to the 3 motor vehicle infractions are not permitted to continue operating vehicle. All right? So this is going on nationwide. They're telling you these people are out there at Christmas watching us because they have nothing better to fucking do. They have no fucking job other than fuck with us in the busiest time of the fucking year. We're out there delivering 400 fucking packages a day. You got these fat, worthless motherfuckers out there fucking with us, saying that if you don't have your seatbelt on, now you got people out there that may accidentally forget to put their seatbelt on because they're hopping out every fucking house with these fucking packages because they're rampant. And you're going to have these dumb, lazy motherfuckers driving up on us. Hey, he don't have a seatbelt on. Send him home. Call EAS and tell them to come, give me your keys. What in the fuck do you mean not having your seatbelt on, driving from that house to that house? And you got an earbud in. You need to be off the clock. That's an emergency situation. That's what you got going on right now because these motherfuckers hate us and we don't hate them enough, right? We should be attacking this nationally. Here's another promise from me to you as Director of City Delivery. When this shit comes out, the day it comes out, you will have a national template the next day. The next day, there will be a national template dispensed when I'm Director of City Delivery. That's a promise. You got an hour office time. The next day, I hear about it. A national template will go out, how we're going to defeat it. You got hip training falsification. A national template will go out, how to defeat that very specific thing. Not just overviews of things. I'm talking about very specific things that we attack on this from 8 arbitration. Those things will be handled nationally. I will make sure that national templates are made exactly what to request, exactly what to do, exactly what to file, exactly what we're going to need for the remedy, how we're going to handle that at the informal, at the formal. B teams will be educated and advocates will be educated, okay? Because the one thing that we're going to do from the very first fucking day is put pressure on individuals. Like Levi Montgomery used to talk to me about. You put pressure on them. They come out with a metric, put pressure on them. Beat that motherfucker to death. They come out with these stupid things here, you put pressure on them. You grieve them nationally, and you pound that motherfucker in the dust. They come out with hip falsification, hour office time, all this shit. You pound these motherfuckers. You put so much pressure on them that it obliterates this shit immediately. We don't have that now because we got too many fucking stupid cowards up at National. So anyway, they're going to come out there, this POD, and they're going to put you on emergency placement. Now, they're going to call EAS and have them come out. Now, this thing you're going to put in every one of your files because it's going to do away with everything that they're going to contend, that the supervisor had full authority to do it. That's what they're going to say. Well, no, I had full authority. They just called me and I determined to put them on emergency placement. Make sure this goes in every one of your files because that will disprove that, right? So I've got some sites for you how we're going to defeat that. Okay? All right, this was quite lengthy. It's from Arbitrator Roberts. This is when it was my case at the informal. This came out of my station. It was a rollaway runaway. Okay? So remember this thing that they've sent out. POD, they're going to drive around. They're going to see you doing something. They're going to stop you. They're going to call EAS. They're going to come out. They're going to put you on emergency placement on the spot. They're going to leave. They're going to get labor involved. Labor's going to write the EP letter. And management, make sure you tell them that they're on emergency placement, right? And so we're going to start at page 10. And all these will be up on from8arbitration.com on this episode, okay? First, management must show that the allegations were real based on an analysis of the information available at the time. There have been cases wherein employees are absolved of all charges, but the emergency placement stood. It's just a matter of whether or not the evidence available at the time of issuance shows the emergency placement was reasonable and justified, based on the circumstances appearing at the given time. There was a lot of evidence introduced in this matter. Interesting was the fact the employer presented a plethora of evidence to show the management made the right decision in this matter. The union also produced evidence to dispute management's claims. However, the written record in this matter clearly and rightfully challenges the employer's own position. It is clear by even the context of the emergency placement letter cited above, dated 29th March 2011, and the unchallenged Joint Exhibit 2 indicating that the accident occurred on or about 12:25 p.m. on the same date. That letter was dated and mailed to the agreement that very same day. The letter itself even states it was mailed via priority mail. Pay attention to me. Aside from all the evidence introduced at the hearing, this documentation provides one very clear admission to me. The agreement was placed on emergency placement solely as a result of the accident, period. There was absolutely little or no investigation. That is clear by the evidence introduced by the employer. And it has the joint exhibit. It's something from the safety supervisor. It is very clear that any evidence was merely an afterthought. The record shows the statement was dated 30th of March, yet the emergency placement had already been decided on 29th of March. And given the time of the accident, approximately 12:30, and the fact that emergency placement letter, in order to be mailed by that same 29th March date, had to be completed prior to 5:30 or 6 to make the evening dispatch, there wasn't much time left for any type of reasonable investigation to have occurred. And I'm of the considered opinion that even though my personal criteria has been that snapshot of time given emergency placement in this case, I do not believe that management had a reasonable opportunity to take a good picture of the facts of this matter. Part of the basis of finding is the fact that 29th March emergency placement letter fails to make a single reference to the rollaway. Quite frankly, other than surmise, there was absolutely no link that an emergency placement letter of the agreement to the rollaway. In fact, there is absolutely no reference whatsoever to the rollaway in the emergency placement letter. Also significant is the fact the agreement testified she was returning from a delivery when the vehicle started to move. I was convinced that had the parking brake not been set, the vehicle would have been moving down the hill immediately after the agreement exited the vehicle, and I would believe that any type of investigation would certainly lead to a similar conclusion. But all this only leads to the conclusion of a clear lack of investigation by the employer prior to issuing an emergency placement. Following further contemplation of this entire matter, the undersigned is of the considered opinion there was certainly a rush to judgment in this case, and the convincing evidence in all of this was the time frame that sits on this record. The accident happened at 12:30 p.m. The investigating supervisor traveled from the office to the accident scene. Pay attention to me. Pay attention to me. The investigating supervisor traveled from the office to the accident scene, took a variety of pictures, interviewed the mechanic, talked to the grievant, verbally informed the grievant of emergency placement, then after all that, made it back to the office and wrote a letter to the grievant that included none of the above, and that letter met the dispatch that day. Joint Exhibit 2, page 117, indicates the emergency placement letter was received by the grievant at 11:53 a.m. on 3:30. I'm of the considered opinion that in order for all of this to happen within the short time frame allowed very little time for any investigation, let alone consideration of the facts to take place. The supervisor, who allegedly considered all the facts in this case and issued the subsequent emergency placement letter, clearly failed to consider all the facts in this matter. Even if all the facts are to be detriment of the grievant, which I doubt, the time frame of what happened in this case clearly prejudiced the grievant in this matter. And confirming this rush to judgment was the fact the supervisor, customer services, clearly failed to include any detail whatsoever in that 29th March 2011 emergency placement letter. Each case is different. This wasn't a matter of bodily harm by an individual or a threat to either another employee or anyone else for that matter. And given the circumstances of this case, I'm of the considered opinion that it was clearly a hurried decision and the emergency placement was clearly in error. As I previously stated in numerous other decisions, the emergency placement in any case must be shown to have been justified with the facts available at the time, snapshot in time. And in this case, when that snapshot was taken, it was clear the employer simply based the decision in total that a runaway had occurred. I was convinced that nothing else was even considered by the supervisor. Instead, I believe the supervisor was convinced of the grievant's guilt as soon as he had learned of the rollaway that day. Now, when you look at this letter, this supervisor that's going to come out there is convinced of your guilt because he was told by somebody else. He hasn't seen a thing, right? So when they get out there, they've already told them what's going to happen. There is a new policy in place that if any of these things occur, these people will be put off the clock. And they will say what? For violation of safety rules. But there still must be an existing emergency to put you off the clock, and I'll talk about that in just a second. We now have a policy from management, nationally, this is going on nationally, a policy where dumb fuckers, fat-ass motherfuckers are going to come out there on the street because they ain't got nothing fucking better to do. We're losing billions, and you got some dumb fuck driving around out there trying to catch somebody, working their fucking asses off, delivering all these fucking packages. And they're going to get in there and they may have accidentally left an earpiece in or forgotten to put their seatbelt on, which fucking happens when you're delivering 400 fucking packages a day. And you got these dumb shits going to come out there, catch you, call your supervisor and say, hey, according to this new policy we have that y'all are going to have from arbitration, right? It's going to be put up. They have to be put off the clock. Get labor, write up a letter. That's what's fixing to happen. We're going to address it right here, though. I carefully reviewed the entire Joint 2 package and was not able to find any content that would satisfy the Mittenthal requirement cited above. The generic content of the 29th March 2011 document did not satisfy that requisite requirement. The agreement was never made formally aware of the charges. Remember when we talk about the charges? He cites National Arbitrator Mittenthal that talks about can't effectively agree without the charge. Remember I talked about that last week? I'll read it again. The agreement was never formally made aware of the charges. When I talk about the charges, too vague. When you have, especially emergency placement letters, because they just run out with it, it's too vague. For the 29th March document is only general in nature and made no specific reference to any of the charges that were presented in detail at the hearing. The agreement was never provided a formal written detail of the charges. In fact, the only charge that shows on the record in this case is that of the alleged failure to follow safety rules and regulations and the zero tolerance policy. I would not expect anyone to put together a defense to such a broad charge. The employer takes the position that the grievant should have been very well aware of the charges against her. However, arbitrator Menthal sees it differently, and his precedent-setting decision has survived several sessions of negotiation. Most significant is the fact that it just makes common sense. When the employer issues an emergency placement, oftentimes it's done on the spur of the moment. That is the entire purpose of Article 16.7. However, at some point in time, within a reasonable time frame of that spur-of-the-moment decision, the employee is contractually entitled to a detailed written explanation of the charges, if for no other reason. This forces the employer to memorialize the charges and allow the grievant union to counter a defense. Remember last week when I was talking about the importance of the charge? This matter was found to be procedurally defective on two separate and distinct counts. First, I'm of the considered opinion the supervisor failed to perform a proper investigation. Here, yours will do none. They'll be given some kind of synopsis from these dumb fuckers. The fact the grievant was involved in a rollaway accident in and of itself does not constitute immediate guilt and fault. Secondly, the employer failed to provide the grievant union a formal charge. The failure to follow safety regulations and the zero tolerance policy fails to meet the requisite requirements of Article 16.7. Had the recommended process been followed by the employer, the supervisor would have certainly reconsidered the initial decision to employ an emergency placement in the first place. Therefore, based on the reasoning set forth above, the emergency placement of the 29th March is found to be without merit, and with that, the second issue becomes moot. So there's a fantastic one. Here's another one from arbitrator Nicholas Duda. And like I said, all these will be up on the From A to Arbitration page, okay? This is what he says on page 15. On seeing grievant from a distance making a U-turn, Mr. Flack immediately decided to place grievant in an emergency placement without any consideration of the conditions. Later, he wrote an observation describing his actions to be taken as progressive discipline. Not using a seatbelt does not in and of itself present a threat of harm. It is intended to minimize risk of injury to the driver if the vehicle is involved in an accident. Making a U-turn could present a risk of injury depending on the situation, but as evidence in the ordinance cited by the service, making a U-turn does not per se constitute imminent danger. These actions, as well as others, talking on a cell phone while driving or leaving a vehicle with a motor running, might warrant a pre-disciplinary investigation, which could lead to discipline under Section 3, 4, and 5, and 16, just as the pre-disciplinary investigation of the April 2000 conduct resulted in a notice of proposed removal. However, the actions under those sections give the employee just cause protections. For example, they require an investigation in which grievant is presumed innocent until the fact finding determines otherwise, and an express statement of charges in advance which the employee can address. Here, the emergency placement letter implied the grievant had violated safety rules and regulations, but it did not specify any until the Step B decision, almost 2 months later. Except in a true emergency situation, the service must state its specific charge and give the employee an opportunity to defend herself while still on the clock. It behooved the service to show, which it did not even attempt, that grievance actions presented such an imminent threat that she had to be taken off the clock immediately and denied the rights normally attended even in a discharge action. In a given case, even if off-duty placement is appropriate, the service must act promptly to reach a resolution. There was no prompt resolution here. Grievant remained off the clock for almost 3 months until she was removed on June 30th. So they have to show that there was an imminent threat. And he talks about, even if I'm on the phone, even if I have no seatbelt on, that doesn't warrant an emergency situation. Another thing, if the carrier is still on emergency placement the next day, what is the threat? Why is the carrier still on emergency placement on the next day? And those are questions we're going to have to ask. We are vastly understaffed right now. And you got these dumb shitheads out there riding around trying to find somebody without a seatbelt on so they can throw them off the clock. I'd ask my supervisor, why are they still off the clock the next day? What is the emergency? If you're going to say that the emergency is no seatbelt on, which I gave you a good decision right there that says it's not. If you're going to say that, why are they still on emergency placement the next day? What is the emergency? if they have an earbud in? Why couldn't you have something sent out by stupid fuckers from labor saying, if you're driving around and see somebody without their seatbelt on, stop them and tell them to put their seatbelt on? If you're driving around and see somebody with an earbud in, stop them and tell them, hey, I'm so-and-so. Make sure you're not wearing your earbud. Why do you constantly have to fuck with us and try to harm us by putting us off the clock? Why is that necessity of y'all's to fuck with us like that and try to hurt us and harm us? That's all that is. Something as simple that you could stop and say, hey, make sure you got your seatbelt on. I'm so-and-so from safety. I don't do a fucking thing all year long except at December when I come out and fuck with people. But make sure you got your seatbelt on. Why couldn't you do that? Why couldn't you put something out doing that? Instead, you got somebody coming out there, hey, now this is what we're going to do. When you see them, call EAS, stop them, show them your identity, take their keys, make them sit there and wait in this fucking freezing ass cold, and have the stupid fucking supervisor come out there, tell them what's going on, put them off the clock, call labor, fuck with them, tell them to do something because they don't do shit all fucking day either, write up a fucking letter of 16-7 and put this person off the clock for something that could have been resolved with, hey, make sure you got your seatbelt on. I know you're busy. I know you're doing a lot of fucking work. You got a lot of packages. I can see that in there. You're busting your ass. Make sure you keep that seatbelt on, mate. Stay safe. Stay safe out here. Make sure you don't have those earbuds in, all right? Why can't you do that? I tell you what, man. I cannot wait. I cannot wait till I'm director of city delivery, which is going to happen. They will rue the day that they do shit like this. We are fucking coming in abundance, man. Motherfuckers. Anyway, here's another site. Here's another site. All right. Frierson. And all these will be up. Like I said, every single one of these will be up. So when you have somebody saying that they're going to come out there and find you, and you have it on writing, it's going to be in every one of your files. You're going to get on there and you're going to copy these, right? And all of these are going to be in your file. Okay? Every single one of these. Where they're going to, this procedure, go out there, you're going to do this, you're going to call the EAS, you're going to have them come out there and they're going to put them off the clock and make sure you oversee that, and then you're going to get a hold of labor. Anytime you see that, they're taking the authority away from the supervisor, right? So in this decision, it's arbitrator Frierson, or this is arbitrator Holly, I'm sorry. It's arbitrator Holly. Sorry about that. So on page 6, the grievance procedure set forth in Article 15 of the National Agreement provides that first step grievance discussions must be with the grievance immediate supervisor, and the supervisor shall have authority to settle the grievance. In the instant case, the appropriate representatives met at step 1, but a serious question arises regarding the supervisor's authority to settle the grievance. Can one realistically assume that the supervisor had authority to settle the grievance in this situation, where the removal action had been initiated by the Sectional Center Directive of Employee and Labor Relations? Obviously not. And the step 1 procedure was no more than a charade. So he's agreeing with us here. Well, we put this in the file. Here's what they said we're going to do. We're going to catch them. We're going to call EAS. They're going to come out. We're going to stand there while they put them on emergency placement. You have relieved the supervisor of any authority. There's no investigation. It's mandated on that they put them off the clock. There is no other option or alternative on there. They don't say, we're going to tell the EAS what happened and then leave. Let them decide what they're going to do. They have already determined what's going to happen when the supervisor comes out there. So they have predetermined the discipline that you're going to get, because National Arbitrator said what when 16-7? It is discipline. It's the worst kind of discipline. It's the most punitive kind of discipline besides removal, because it immediately removes you from your livelihood, from a pay status. Okay? So I'll read that again. The grievance procedure set forth in Article 15 of the National Agreement provides that first step grievance discussions must be with the grievance immediate supervisor, and the supervisor shall have authority to settle the grievance. In the instant case, the appropriate representatives met at step 1, but a serious question arises regarding the supervisor's authority to settle the grievance. Can one realistically assume that the supervisor had authority to settle the grievance in this situation, where the removal action had been initiated by the Sectional Center Director of Employee and Labor Relations? Identical to what we're talking about. Obviously not. And the step 1 procedure was nothing more than a charade. The contractual provisions regarding Step 2 provide that on the appealed grievance, the installation head or designee will meet with the steward. The clear intent of this provision is to assure that an authority higher than the employer representative who initiated the action which gave rise to the grievance will be the employee's hearing representative. This condition was not met since the employee representative at Step 2 was the same official who initiated the removal action, that is, the sectional center director of employee and labor relations. Hence, Step 2, like Step 1, was ineffective and meaningless, and as a consequence, the grievance was deprived of procedural due process. And remember, emergency placement is discipline in accordance with National Arbitrator Menthol. Here's another one. This is from National Arbitrator Nolan. And this one will be up as well. And this is what he states. Procedural objections to the validity of the discipline must be resolved before turning to the merits of the discipline case. The most important procedural objections in this case concern the origin of the discipline and management's reliance on certain inappropriate past elements. Article 16.8 requires that a supervisor must discipline and that higher authority must concur. Article 15.2 requires that management Step 1 representative have authority to settle the grievance. The rule of Article 16.8 is a debatable one. Most of the private sector, for example, gets along quite well without it. Were this a case of first impression, and were that section to be read alone, I'd be inclined to interpret that provision loosely as allowing discipline so long as the immediate supervisor participated in the decision. Article 16.8 cannot be read alone, however, and this is not a case of first impression. Article 15.2 clarifies the intention of 16.8 by ensuring that the immediate supervisor can resolve disciplinary grievances as Step 1. This would make sense only if the same supervisor initiated the discipline, for if higher authority initiated it, the first level supervisor would hardly be in a position to reverse that decision. Moreover, several prior arbitration awards interpret these provisions strictly and overturn disciplinary decisions imposed from above, which is exactly what's happening here. See in particular the award of arbitrator Zuma in this case, and the other awards cited there at pages 7 and 8. Those awards interpret these contractual provisions as creating fundamental due process rights, not least because disciplinary decisions made at higher levels turn the first step of the grievance process into a sham. And that's exactly what's happening here. The first phase, the first step, the informal meeting is a sham. It's a charade because someone else has told the supervisor to put you on emergency placement. They didn't see you. They're getting a phone call from some dumb fuck saying, hey, we came out here riding around because we ain't got nothing fucking better to do. And we saw a carrier without their seatbelt on, so come out here and make sure they're put off the clock. They have removed the supervisor from any authority, and that's a violation of my rights to due process. Stability and consistency in labor relations oblige later arbitrators to defer their predecessors in all but the most egregious cases. If they fail to do so, parties would lack guidance for their day-to-day decisions and would be tempted to relitigate every issue in hope of a more favorable arbitrator. Station Manager Hickson's uncontradicted statement that Womack, not Mitchell, initiated discipline establishes that management violated Articles 16.8 and 15.2. Accordingly, I follow the rulings of Arbitrator Zuma and the others and hold that management improperly disciplined the grievance. So there's you some great decisions talking about, one, the charge, right? It's not an emergency. It's not an emergency situation. Two, you've removed the supervisor from any authority because you came in and told them exactly what to do. And so that's how you're going to beat that, okay? So there's two things. We talked about the cowardly position of our union, how they have bought and sold themselves to management, to labor, dealing with escalated monetary awards. Any chance they get to take a shot at that, to say, hey, we've been telling you all along, just do what we say. Make sure that we get these pre-arb sessions where we can save the union money, fuck the city letter carrier. Got that with Barner, got that with his business agent's office. We addressed that, right, thoroughly. We addressed this new thing that came out, okay? We addressed that. I was going to do another segment, but I've got to have Badmouth Morris is going to come on for the CCA Corner. He's coming on in 7 minutes. So I have to stop this one. It's already an hour and 42 minutes. So I'll stop this one. He's going to come on. I'm going to have this one downloaded, and then I'm going to have him downloaded as well. I'll come back and do the second part of this probably tomorrow, okay? And I'm going to talk about pressure, putting pressure on management, how we are not doing that as a union, how we will start doing that when we take over, the CLC takes over. Talking about these videos, okay? So I'm going to get off here for now. There's your 2 things we're going to talk about, right? 2 things that we're going to deal with right there about cowardice, our union being cowards, and about these new policy kind of that management has come out with, okay? So, yeah, cat's out of the bag. I will be the next director of city delivery for the NLC. That's coming. And I make a promise to you now. The city letter carrier will be put first again in this union, right? James Henry has a plan. I've listened to this plan. I'm in full agreement. He is setting the dogs of war out on management. And we will be out there making sure that y'all come into an environment that's free of hostility, that's free of any kind of toxic manager or supervisor, and we will address those things immediately, all right? I love each and every one of you very much, very much. I cannot wait for y'all to hear the rest of this ticket. It's when I say it's the hounds of hell, son, they're coming. The motherfuckers are getting in, and they're fixing to go motherfuckering like this union has never seen, and I cannot wait. All right, I'll have Badmouth Morris on in just a second. That'll be the second episode for today, okay? So y'all take care of yourselves, and I'll talk to y'all probably tomorrow, all right? Bye.